Welcome back to the Professional Edge. My name's Todd, tax attorney, CPA, certified financial planner. And this week we're talking about estate planning essentials. And before we went to break, we had talked about the last will and testament, the document that individuals need to have when they pass away. And that basically identifies who's going to receive what amount of property, when, and who's going to be your decision maker to administer your estate. And also, are we going to have a testamentary trust to protect those beneficiaries? And what do I mean by a testamentary trust? That is a trust that gets established, meaning it gets funded when the person passes away. So if I want to leave my son his inheritance in a trust because I don't trust his spending ability, so therefore I would create that trust, and when I pass away, the $100,000 that I leave him goes into trust. I appoint a trustee, and then I outline the terms and conditions of that trust distribution for his remaining time, or it can be for a period of, let's say, 5 years, 10 years. And it could say simply, I distribute out the income to my son annually. At the end of 10 years, then the final balance of that trust shall go to my son outright, be free for him to choose as he wishes. So another thing on the essentials of estate planning, large sums of life insurance or even 401ks, even house. And when you add everything up, it becomes substantial money. It's your lifetime savings. So we've seen on average that when beneficiaries receive their inheritance, within 93 days, they squander their inheritance. Shocking but true. Yes, 93 days. So your lifetime savings is going to be squandered by your beneficiaries within 93 days. So step back. Here's one of the planning tools, being a tax attorney, completing over 2,000 estate plans. Don't leave your inheritance to your kids outright. Put some strings on it, attach it, and yes, unfortunately, control it from the grave. And the reason being is if I leave this money to my son outright and he should be involved in a creditor claim, then his inheritance is subject to that creditor claim. So we know that over 1/2 of all marriages end in divorce. I think that's on the rise as well as COVID. We sit around with each other and we determine that we don't like each other as much. So we then say we're going to have a divorce. Well, guess what? If my son inherited his $100,000 outright and it was in his name and now he's getting a divorce, didn't keep the property separate, then it's going to be subject to the claims of his ex-spouse. But if I kept the money in a testamentary trust and he then gets a divorce, then there is a strong argument that this $100,000 should actually be excluded from the claims of that ex-spouse. So again, there's not really any downside to putting this in a trust for my beneficiaries, my children, but then there is only upside potential. It is creditor proof. And it's a great planning tool. Death, unfortunately, a lot of people just let this planning opportunity go to the wayside because they don't know the advantages of all the things that you can do with a proper estate plan. And that's where we offer all our listeners here on the Professional Edge a free consultation. If you're away and you get this on a podcast, yes, all shows are now going to be on a podcast as well, so you can listen to it when you can't fall asleep. Just turn on the podcast, and I'm sure this will make you fall back asleep. But anyway, you can call our office at 877-654-9798. That number again, 877-654-9798. We schedule that either at the Cunningham Center. If you want to challenge the traffic here in Atlanta, we can also meet here. Or given the COVID environment, we can do a Zoom call if that's where you want to be. That's fine with me. I'm just trying to get the listeners here on the Professional Edge to get their estate plan done and get it done properly with the benefit and guidance of a true professional, that is the primary focus of their practice. I don't do litigation, and therefore my concentration is on asset protection and estate planning for my clients. So again, take advantage of that 877-654-9798. That number again, 877-654-9798. So back to the estate planning essentials. We were talking about that testamentary trust to leave your kids some money outright when you pass, but then put that final balance away for them, especially if your kids are minors, because we don't want to let that minor child receive a large sum of money at the age of majority. It's 18 here in Georgia. It could be 21 in other states, but that protects them from themselves, and we can allow those trust funds to be used for their education, their maintenance, their support. They're not going to be on the street and have this $1 million trust account that they can't touch. Don't believe in that, but we don't want them buying a Ferrari or a Lamborghini when they reach age 18. That would be a recipe for disaster, and we all know it. But the only way that you can put that in place is to draft your estate plan properly, and that is what we need to have happen as a listener here on the Professional Edge, is get your estate plan done. It's New Year's 2021. You're looking around. If you have an old last will and testament, things have changed. I mean, a lot of people draft one when they have their children, and lo and behold, their children are graduating from college and starting to have grandkids. And they pull out their last will and testament and say, wow, okay, we probably need to change the decision makers. We need to change the plan of distribution. And do we want to peel off some money and put it in trust for the grandchildren for their education and plant that seed so it grows into that mighty oak? So these are all estate planning essentials that you need to consider. It's not overly complex. It's just simple tools that we need to use. Now, if you have a very low basic estate, then obviously you're not going to need a testamentary trust. But if you have some life insurance, you have a 401k, you have a home, you have some other investments, then yes, absolutely got to get your estate plan in place. So we talked about the last will and testament. Now let's turn to a different planning document, and that would be a living trust. A lot of people are confused what a living trust is. The easiest way to conceptualize that is a shoebox. We're going to build a shoebox today and place your items in that shoebox, meaning we got to make sure that things are properly titled. And therefore, if we have that condo down in Florida, then we can actually avoid ancillary probate and not have a probate estate in Florida and a probate estate in Georgia, Alabama, or your domicile state. So if you have multiple pieces of property in multiple states, then this might be the ultimate planning tool for you. That way we, keep your affairs private, number one. Number two, we can avoid the ancillary probate by doing a little bit of work up front. So again, a trust keeps your affairs private, whereas a last will and testament, it is 100% public display of information. Because remember, we are filing that last will and testament down in the probate court, and all you have to do is walk into the probate court and you can look at all the probate records. It is public information. So being in Columbus, in a small town, a lot of people don't want to share their business, share their laundry. So one way to avoid that is to plan your estate with a revocable living trust. When you pass away, then no one can go to the probate court and find out what you actually owned or to whom it's to go to or what amount. So again, that's another planning opportunity for you is do a little planning on the front side, avoid probate, and avoid the administration time, the delay of probating an estate. A lot of times the quickest you can do that is you got to keep the estate open 6 months to allow the creditors to potentially make their claim. Then you can administer your estate, but the average estate takes anywhere from 9 months to 2 years to administer it. Plus you have most of the time an attorney involved helping you administer that estate. And therefore, if you want to keep the attorney out of your pocket, I am one. But I think the client, you as a listener here on the Professional Edge, you're not a client, but I think you need to be advised there's two ways to plan your estate. One is with the last will and testament. The other one was if you use a living trust. It's a benefit. One might not be needed, where the other one is highly beneficial to you. So again, to make that determination, we give all our listeners a free consultation at 877-654-9798. That number again, 877-654-9798. Again, meeting at the Cunningham Center, Atlanta, or in this environment, a Zoom meeting of all things. We send out some information together, and then we sit down and determine what makes the most sense for you and your family on making the plan of distribution the most efficient and protecting the beneficiaries as well. Might even have a blended family. A lot of individuals get divorced, get remarried, and he's got his kids, she's got her kids, and you may even have his and her kids. So with that as well, it gets a little trickier to make sure that things go in the right order to the right beneficiaries. Because if we have this will that leaves everything to the surviving spouse, and this is a second marriage, guess what? The kids of the first marriage are completely disinherited. I'm not sure that's the intent of the parties, but unfortunately, trying to be cheap and not walking through things with a qualified licensed attorney that does this on a regular basis, then that has the potential of happening. So again, a blended family, it's a wake-up call. Make sure you protect each other and make sure you protect your own children. The only way you can do that is with a proper estate plan, having your estate planning essentials covered. So again, dial the number 877-654-9798. That number again, 877-654-9798. And one place you might want to stop by as well as EMC The Bundle. EMC, Echo Mary Charlie The Bundle. It's a great combination, being a tax attorney, a CPA, certified financial planner. It's an integrated approach to get your estate plan done, get your retirement planning done, and some additional tax planning. So again, check that out at emcthebundle.com. That is EMC, Echo Mary Charlie, thebundle.com. My name's Todd, tax attorney, CPA, certified financial planner. More coming up after the break. Thanks for listening in.
With today's financial markets, are you getting the personal and professional attention you and your money deserve? Clients of estate management counselors benefit from having one set of professionals advise them on their tax, estate planning, and investment advice. We call that the professional edge. Todd is a tax attorney, CPA, and certified financial planner. With over 15 years' experience, he welcomes the opportunity to assist you in preparing for retirement, implement effective tax planning strategies, and to help you properly plan your estate. His radio show, The Professional Edge, is aired weekly on Sundays at 9 a.m. If you're interested in meeting with call his office at 877-654-9798. That's 877-654-9798. Do you want to feel more confident about making the right investment, tax, and estate planning decisions? Today, these decisions are more complex than ever. Have you thought about working with a professional advisor and not sure who to turn to? Not sure what qualifies one to be an advisor? Todd is more than qualified as a tax attorney, CPA, and certified financial planner. Is with Estate Management Counselors. Estate Management Counselors operates as an independent fee-only investment advisory firm. They're dedicated to gaining a personal understanding of their clients' objectives and implementing professional counsel and advice to achieve those objectives. So take a second to talk with Todd to learn how you can benefit from their multidisciplinary practice where they coordinate their clients' legal, tax, and investment strategies into one comprehensive and integrated plan to enhance and protect their clients' financial security. You can reach estate management counselors and speak with Todd by calling 1-877-654-9798. That's 1-877-654-9798.